morning and good afternoon to in-house counsel from all across North America. Welcome to In-House Connect. My name is Shai Mahani. I'm the CEO and co-founder of In-House Connect, and I'm thrilled to have you here with us today. Thank you for joining us. Thank you for spending your breakfast time or your lunchtime with us. This is probably the last hurrah for you before your long weekend for all our US-based audience. And special thanks, of course, to Streamline AI for sponsoring today's program, and to our fantastic panelists, Kathy Zhu and Yumi Lawler, who are going to teach us how to enhance legal ethics and professional responsibility through technology. This is our 39th event of the year, and I'm wondering, are you here for the first time or have you been with us before? Looking at the poll, it looks like we are at a 87 to 13% split. So 13% are new and 87% are returning. So welcome to the 13% and welcome back to the 87%. It is great to spend time with you. Okay, today's event, Enhancing Legal Ethics and Professional Responsibility Through Technology, a guide for in-house counsel. Our presenters today are Kathy Zhu and Yumi Lawler. Kathy is the co-founder and CEO of Streamline AI, a legal process management platform purpose-built for in-house legal teams to handle intelligent intake, workflow, automation, collaboration, data knowledge management, and reporting. Kathy was most recently the Associate General Counsel at DoorDash, where she spent 4 years building a commercial and legal operations function from the ground up, and she supported the company's growth from $4 billion to over $70 billion in valuation. Kathy started her career as a corporate lawyer at Wilson Sonsini, advising over 30 startups through venture financings, M&A, and IPOs. Following that, she spent 4 years at Medallia, a customer experience management software platform where she was promoted to director, commercial legal. In her free time, Kathy is a dedicated mediator, golden doodle mom, and scuba enthusiast. And of course, last but certainly not least, our next panelist is Yumi Lawler. Yumi is the general counsel of January Technologies, a startup on a mission to make debt collection human. Prior to joining January, Yumi served as in-house counsel at Etsy, Instacart, and Macy's. Again, rockstar panel, great topic, and I'm thrilled to turn things over to Kathy to get us started.
Thank you so much, Shai. It's wonderful to be here. Welcome to all of our guests. Streamline AI is very excited to bring you this legal ethics webinar today on how to enhance your legal ethics and professional responsibilities through the use of technology. So before we kick off, I really want to give Yumi a big thanks for suggesting this as the subject of our CLE today. It actually came up during a community dinner hosted by Streamline AI. And, it's been so much fun collaborating with her on this. Hopefully this topic feels as refreshing and a unique twist to you as it did to me when she first suggested it. Yumi, any thoughts before we dive in and give our backgrounds?
Thanks, Kathy, for presenting this topic with me. I think what I really wanted to highlight is that in this moment when trust in lawyers is questioned, especially in light of our technological prowess, I feel this is a particularly important topic, and I'm really excited to dive in.
Amazing.
So I love that our beautiful photos are on here. We look better in person, I think. And Shai, thank you so much for our intros, and I feel like that covers it. I became an attorney because I believe that we all need someone we can trust to address the trials and tribulations of our time, no matter how mundane or novel those issues are. And began my legal career in entertainment law, and then switched over to the consumer side, companies who work with consumers every day. And I learned a great deal about how we can focus on our responsibilities as lawyers, especially as in-house attorneys, while at Macy's, Instacart, and Etsy, and now at January Technologies, navigating it as general counsel. And I see in the chat that we've got a lot of GCs in here and wonderful people from all over the country with interesting experiences. And so we're really excited to share this information with you and get to know each other more.
Awesome. Thanks, Yumi. And like you said, I think Shai gave such a great background. I'm not going to repeat it other than just kind of sharing the founding story to Streamline in case it's kind of interesting. It's a little different from most founding stories since I did spend the first 10 years of my career practicing as an attorney. Got lots of great experience. In fact, I really, really enjoyed my job. I never thought that one day I would leave, right, and become a founder of a startup. But my big epiphany during my time in-house is that legal teams often don't have the right tools that were designed for the unique way that we work. And actually that manual processes, just handling requests from the business, really resulted in a lot of inefficiencies. That we're wasting tons of time just having inefficient back and forths with the business to get context, digging through emails and Slacks to figure out what happened historically. we don't have metrics to report on all of our amazing work back to the business. So that's really what led to the founding of Streamline. And again, super excited to be here. So next, Yumi will preview the agenda for the CLE and help to set some context for us.
Thanks, Kathy. This is our agenda slide, and we've set our agenda up like a mullet: business up front, party in the back, where we talk about the critical responsibility and leveraging technology in light of our legal ethical responsibilities. And we organize our agenda in this way because now more than ever, business stakeholders within our organizations are working at a much faster speed than any one individual or small team of attorneys can address. And especially given the pandemic from COVID-19, we've seen the rise of remote and hybrid work, which has really accelerated the adoption of technology throughout the company for communication, like Zoom, what we're using now, Slack, Teams, or any other tool that you guys use for collaboration. I think legal teams have historically been slow to adapt technology because A, we want to review the terms, but B, we want to understand how that technology can be utilized in our practice, especially pursuant to our ethical responsibilities. And given the fact that we have to preserve our client confidentiality, our attorney-client privilege, and other concerns, it's really important to understand what's out there and what we can definitely leverage. So Kathy and I were held here to talk about the use of technology in our practice as lawyers and how it's something that our legal ethics really encourage, in our opinion. So before we go forward, I do also want to just disclose that we're not going to be addressing other legal ethical concerns that in-house counsel address. So an example that we've seen in other presentations are like, who is the client? How do you work across jurisdictions? How do you register as in-house counsel? Is that required? How to work ethically as a remote employee? But we do touch upon some of those things with the technological concerns that we will address. Privilege and maybe waiver issues, and also whistleblower protections that there are a bevy of presentations out there, but we're not going to be addressing in this conversation. And so with that, I want to address that it's part of our ethical duty to stay up to date on a lot of the things that we're going to be discussing now and also the things that we'll be addressing in the future. I know in New York, on Tuesday, Shai's team presented a presentation on generative AI. And so I encourage that we continue working to seek out those presentations as we figure out how do we be the best attorney that we can be within our legal ethical grounds. Kathy.
Thanks so much, Yumi. Just a little bit about, how Yumi and I will be dividing up our roles with respect to this presentation. So Yumi will run point on summarizing the relevant model rules on ethics and professional responsibility and digging into the intersection of those rules and technology. And I will be providing some additional color, some additional examples from my own personal experiences and some guidance for you all as well, straddling, now my roles between legal as well as technology founder. And at the end of the presentation, we'll provide practical tips on different types of technologies that you can use to supercharge your work. So we're really trying to leave you with nuggets, right, that you can put into practice right away. And then be on the lookout for the light bulb symbol on the slides. Those will share little nuggets of advice along the way. Again, we're all about making this as practical as possible. So before we get started, tell us in the chat how much you already know about generative AI. We're curious and we want to hear from you. And now passing it over to Yumi to get us started from guidance from the state bars.
Thanks, Kathy. And if you don't know anything about generative AI, it's okay. We're going to address it later on too. So yes, Armando, we hear you. So we'll get to that. But for this slide, judging from our greetings in the chat, we've got attorneys licensed across all jurisdictions in the United States. And so Karen, she's going to drop a link to the chat in the chat to demonstrate comparisons of the American Bar Association model rules to the various state rules that exist so that you can find the specific language that could be relevant to you. And so on this slide, you'll see that we've got some samples from the State Bar of California. And we're also seeing just in general that various bar associations have been addressing how we use technology in our everyday practice. The American Bar Association's House of Delegates actually amended the standard of competence to include technology back in 2012. And since then, the majority of states have adopted the changes that have been recommended, and also the model rules, which we all probably, hopefully remember from our ethics course in law school. And as of late 2017, we've seen 28 states adopt the amended language from that 2012 House of Delegates conference that was provided in their amended language. And so you'll see it in regards to the link that Karen provided, and also throughout your own state bar's ethics rules. But what's most important to highlight here, especially with these opinions, is that our state bars are addressing the issues very slowly. Like you'll see on this list, the first one is from 2012, and then the last one was from 2020 about data breaches. It's slow, but it's sure that the state bars are coming out with opinions. And as we're thinking about how we use it in our practice, we should look to some data as well. In 2021, Gartner published a study that found legal teams are quickly adopting technology. And by 2024, the study found that up to 50% of legal work will be automated. And I think that's really important to understand, especially given the fact that automation isn't the end all be all of our work. It's going to be something that maybe hypercharges how we do our work effectively and efficiently. And so depending on how you feel about technology, this may bode well for you in your practice, but ultimately we hope that it'll enlighten you in how we really can become more human in our work as attorneys. And so we'll use this opportunity to use the model rules as written by the American Bar Association. And I hope that you can rely on the jurisdictional tables that are provided in the hyperlinks that's contained in the one link that Karen dropped earlier. And if you do have a particular question, Kathy and I were members of the California Bar, and we may be able to answer your questions on this particular topic, but we shall see. So we hope to be able to address it more fully as we address each rule that we think is pertinent to this discussion. So the first one is with regards to the duty of competence. I would say that a lot of how we practice law is contained in rule number 1 of the model rules. And we'll be sure to post the jurisdictional link that I was mentioning, Deborah. And with regards to model rule number 1.1, this is important because we always think about competence from a substance perspective. And so this one states that a lawyer shall provide competent representation to a client, which requires the legal knowledge, and here I'm highlighting skill, thoroughness, and preparation reasonably necessary for that representation. And so we inherently believe that that requires us to keep up with the technological developments because our clients, our stakeholders and internal teams that we're working with, they're using a lot of tools to help us meet them where they are, and we need to understand how to do that. And so without understanding the demands of our business and our teams, and if it happens repeatedly, it could probably be seen as reckless, that we're not necessarily competent in delivering our legal advice and conveying it and communicating it because we're not there yet.
Yeah, Yumi, that was totally resonates with my experience. And, just sharing and double clicking on that a little bit around the importance of, just being able to meet our clients right where they are. Big transition that I personally made was from law firm to in-house. And what I realized very quickly is that the manner by which, we are competently providing our services, right, is so radically different in those contexts. And exactly as you shared, we're trained, right, as junior associates to focus on the substance, often writing really, huge memos, and we're mostly communicating to lawyers. But obviously that totally changed when I went in-house. I know our audience is all comprised of entirely in-house counsel. And you probably all experience this. If you write an email longer than 3 paragraphs, no one reads it, right? So I started putting, a TLDR like summary at the top of every email, breaking things down into bullets, making it as bite-sized as possible. And that's when I realized that modifying my approach to counseling was really imperative to competently delivering my services as an in-house attorney. And technology played a really big role in that. To your point, Yumi, about the importance of keeping up to date with technology. If the business thinks that legal lives on an island and is super siloed, and that legal refuses to use any of the tools that the rest of the business is using, then in my opinion, the business is probably less likely to accept our guidance, and worse still, may even try to make efforts to avoid us. They'll think of us as a blocker. And technology really helped me personally to break down a lot of those walls. And my opinion is that if legal has a strong brand within the business, we can actually create a lot of influence and change, and the business will come along, right? And if we embrace technology, that also becomes part of our brand. And then the business starts to see legal as being innovators, just like they are. So, this is really how we start creating bridges, right, with the rest of the business. One of our customers actually shared that they wanted legal to be on the tip of the spear, actually guiding and leading and bringing in the newest technologies that then they can share with their business counterparts. And I'm like, wow, what a radical way of flipping the script. It's amazing, but we're seeing examples of that. So speaking about building bridges, this leads very nicely to our next topic on the duty of diligence. Yumi, please take it away.
Thank you. And next slide, please. So this model rule is super simple. I would say most states have adopted it as is. A lawyer shall act with reasonable diligence and promptness in representing a client. And so as in-house counsel, that this definitely applies, and certainly applies to us because our stakeholders are part of the client that we represent. And that reasonable diligence and promptness is required in our issue spotting. And so if we don't know something exists or if something is an issue, how do we know to competently deliver those services? And I feel like the principle of diligence here is really with regards to expectation management. Reasonableness is a standard that may adapt with time depending on what's out there, but it's definitely about, getting back to the business in a reasonable amount of time. And timeliness to responses is often business's first perception of how they perceive the legal team and your compliance team or whomever you're supervising. And that's super important because that goes back to how well will you be utilized in the company, and how competent will you be deemed if you're not actually providing legal services because you're not being reached out to. And so diligence, I feel like, is super important when you're thinking about your role, especially for me as a solo general counsel. As the only attorney on my team, we've got compliance team members across our company, but I'm servicing the legal needs of our busy and growing company, and we want to make sure that it's well staffed. And currently, at the size that we're about 50 plus employees. It seems relatively the right number of attorneys in-house to serve, but there might be some things where the team is expecting a 24-hour turnaround, or they need an update on something because it pertains to their business, or they're talking to a client about an audit or some regulator knocking on their door. And so this is something where we need to understand how we can provide with promptness the things that the client needs when they're relating to third parties and other government agencies.
So can I gripe a little bit about this?
Absolutely.
Because everything you said is absolutely spot on. And unfortunately, what often feels reasonable to the business doesn't feel reasonable to us, or maybe even not humanly possible, right? Because we're so leanly staffed and we're supporting so many people. And so this is my gripe, right? Because sometimes, when there's a misalignment of expectations between us and the business, it results in escalations, especially ones that feel really unfair. And type in the chat if you've ever run into this. I feel like this is a very common experience for in-house counsel. So it's also one of the most painful aspects of my practice. And I'm just going to be real for a moment. I'll share this real story where the very last day of a quarter, back when I was, in-house with a SaaS company, and I think I spent probably maybe 6 hours to get back to the salesperson, and they escalated not just to the GC, but also copied the head of sales, I think it was like the CRO, and then also copied the CEO as well, and completely threw me under the bus. And I was just thinking like, oh my gosh, right? My career is done. Obviously it wasn't, thankfully, but just highlights, the experience that sometimes we have where we feel like we're working so hard, but there's still the complaint, there's still the escalations that happen. And how is this feasible for us when I was supporting 1,000 people when I first started at DoorDash. So how do you meet all these expectations? Because exactly what you said, Yumi, is correct. I think that, perception is reality here, right? If they feel like legal is a blocker, legal is what's preventing them from getting their stuff done, then there's this, huge misalignment. So this is what I found to be the answer, or at least very, very helpful. And it was gathering data. So business teams listen to and they respect data. And if you're telling them that requests, that are sent to the legal team take on average 20 days to complete, but 18 of those days are actually spent waiting for the counterparty, waiting for other approval teams, it's actually only with the legal team for 2 days, the perception shifts entirely. So I think a lot of this is also absolutely like, we shouldn't just sit back. Obviously, none of us are, right? We're working really, really hard, but it's about managing those expectations using data. And our customers have actually created reports with the data from Streamline showing that business approvers are actually responsible for requests getting stuck in the waiting on status and how many days, and really breaking down those SLAs and which business teams are responsible for sending legal that greatest number of rejected or canceled tickets, which really, come on, that's completely taking up our time, right? Working on things that we shouldn't be. So shining a light into that black box is super, super important. So I encourage you, to move away from managing your work manually from inboxes, implement technology, really help you to actually get the data. Again, I'd love to hear from you. If you're getting your hands on metrics, put it into the chat. How are you doing it today? How has that been helpful for you to manage those expectations? And next, I'm going to pass it back to Yumi, who's going to talk to us about the duty of communication.
It goes hand in hand, diligence and communication, especially when you're working and corresponding with folks in-house. This one's model rule 1.4. I would say even most states have numbered it 1.4 and copied it as is, and the emphasis is our own. But we should promptly inform the client of any decision or circumstance with respect to which the client's informed consent, as defined in section 1.e, is required. And so 1.e defines informed consent as the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation about the material risks and makes that reasonably available alternatives to the proposed course of conduct. And so all those options and the optionality, especially when it comes to deals, like pointing out all the issues and all the provisions that are at issue, that's something that's a part of this. But the other parts of communication really deal with what those objectives are. And so subsection T2 is about reasonable consulting about those objectives. And number 3 is about keeping them informed of the status of the matter. Now, you guys probably get pinged all the time via Slack or email. Hey, what's up with this? Bumping this to the top of your inbox. And so this is something where with the use of technology, they don't even have to bother you directly. They can just use your dashboard or whatever tool you guys have access to. And number 4 is promptly complying with those reasonable requests for information. And so a lot of times we're so mired in working on redlining the contract or reading through answers for litigation that we're working on. We're pretty busy. And so to be prompt requires us to respond to every individual request. And I think that's something that technology can certainly help us with as well. And number 5 is about getting any of that relevant information or the limitations out there so that the client or our business team doesn't think that we can promise the world to them. We can only promise the world with an asterisk footnote. There are some exceptions to this, et cetera. And so this is something that's definitely required by us. This one's pulled directly from the California language, but the ABA model rule has very similar language. And this is something, as subsection B, we have to be able to explain to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. And so a lot of times you're working with stakeholders who, if it's a deal or any other thing that you're representing them on, requires that they know what the repercussions are of what the implications of their decisions are. And so a lot of times software creates playbooks for you, or there's something that you can build in, or a clause library or explainers for your team. And so this is something that can definitely ease in your duty of communication when you have a tool that has repeated all those actions that you probably do on a day-to-day basis. And I think Kathy probably has a lot more to add here.
Thanks, Yumi. I'm getting so excited just seeing some of the comments from the chat. It really feels like people are resonating from our experience. And you know, if you're curious and you want a tool that gives you metrics like that, take a look at Streamline. You can ask for a demo. We'd love to show you what we do. So again, you know, I think it's easier to comply, right, with this duty. It's really difficult to comply with this in an in-house setting. I think it's easier in a law firm setting. Providing routine updates on legal requests from the business, really hard in-house because legal is often responsible for shepherding a matter from end to end, even when sometimes we just need to have one particular sliver of the overall pie, right? Like we're actually quarterbacking that entire process, going from different approval team to approval team. Like you have to go to InfoSec sometimes for a vendor request and explain exactly what the vendor is doing. Then you have to follow up. You're shepherding that communication back and forth between InfoSec and the business. And it takes up so much of our time. Think about how much time you waste every single day just handling this duty. But like Yumi's saying, you know, this is also super critical, right? Keeping the business up to date. It's actually part of our ethical responsibility. So the good news is, you know, again, like completely agreeing with Yumi here, technology solutions are so essential, right? It can help you to really cut down on the level of effort that you're putting in to meeting this obligation, right? It can help you keep audit trails, send notifications, keep everyone looped in. So you don't have to do that work manually. The system does it for you. And there are tools now, hint, hint, that you can, you know, even use, right, to build your own workflows with no code. You can automatically trigger communications based on the type of request, which team that request is from, how it's moving through the process. And today, if you're not using these tools, that's all time spent, you know, by you, right? Taking away from things that really deliver value that can help the business move forward. So drum roll to our very, very first attendee poll here.
It looks like 19% are not at all involved. 33% are minimally involved, 26% are pretty involved, and 22% are very involved. They steer the processes, they make the decisions. So there you go. There's our poll.
Super interesting, pretty evenly spread. Sorry, go ahead. Yumi.
Yeah. Well, also I think that gives us a lot of hope. So even if you're not at all involved, minimally involved, or pretty involved, I think as folks who are stakeholders and utilizing these tools, you guys have a lot of soft power to talk about what's really going to help you efficiently do your job, especially given the fact that you probably are managers too, which is a segue to this slide. But Kathy, did you have anything else to add?
Please, back to Yumi. So Yumi's going to walk us through the duty to oversee work.
Actually, I'm just going to keep passing it off to somebody else, but no, we'll do duty to oversee work. So the one on this presentation shows California's Rule 5.1. Certainly, there's the Model Rule 5.1, which is titled Responsibilities of Partner or Supervisory Lawyer. And so this one, in essence, because it's a chunk of text, and although we specialize in reading chunks of text, I'll leave it here, but it's basically, if you're at the core of this rule is, if you're an attorney that is directing other attorneys or legal professionals to serve your client, it has to be within or consistent with our ethical duties. And so that's competence, that's diligence, all the things that we've mentioned here, and all the other rules that exist. And so even the Model Rule 5.1 deals with law firms, and especially, and also the California rule here, there are some state variations that you'll see in the link that Karen linked earlier. So some of those changes also refer to just all legal professionals that may be within your team, may also represent whether you're an attorney at government agencies and the like. But I think the core of this is essentially that, which is if you're directing somebody to support you in providing client services, it has to be within your ethical bounds. And we're all working, if we're lucky, on teams of lawyers and non-lawyers, and we're also providing advice and counsel internally, and we're also working with our outside counsel to support us in what they're providing. And so it has to be relevant, it has to be pertinent to the issues that we spotted or the issues that our teams have supported us in spotting, so that we can communicate the work that needs to be done and actually be able to deliver those services. And it's very hard to do if you aren't communicating with your own teams and the teams that you're working on external to your own, those issues that you've spotted and the work that you're actually supporting. And so this duty to oversee work is within reasonable bounds. And so whatever you're able to do, however, we've highlighted within the comments that it can be really difficult accessing those particular documents or being able to communicate to our teams because we just don't have the tools there because our teams are moving so fast. And so I think the underlying message we've got for this model rule in terms of overseeing work is that to be able to be fully connected with the diversity of work, with the complexity of work, and with the magnitude of work that we're now doing. And I think this is only going to be an increasing problem as we move towards the future, because as individuals, we're going to be able to handle so many more things than we're able to do now because of our technological capabilities. It's important to be able to seek out those tools that are going to help us be more human in our lawyering, and also maybe more robotic in the things that we don't need to humanize, especially when it comes to conveying that information. Kathy, do you have anything to add to this?
Thanks, Yumi. Yeah, I, really found this a tough one, right? I led a team of 12, my last role. And one of the biggest challenges, especially during the pandemic, when we switched to remote work, was not having the right level of visibility into what everyone was working on. And as managers, we have to figure things out like load balancing, performance management, resource allocation, right? You don't want anyone on your teams to be sitting, twiddling their thumbs or mostly burning out, which, it's really hard when you're not in the office together. And even if you are, it's still hard. So I think a lot of us can probably, relate to this. And frankly, even as a GC, I still spent a lot of my time just managing up and helping the GC kind of understand what is my function, working on, what are we prioritizing? And you have to wonder, isn't all of that time kind of just communicating the work? Isn't that better spent actually focusing on the work? Is there an actual tool that can help us really get visibility into everything that's going on, not just transactional, but everything coming into the legal team? And so that's what I did. I actually created a really hacky system to track all of the work that came into the team. And it was so helpful to start getting the data and start seeing, what are completion rates looking like? What is the volume looking like? And I could use that as a way to kind of figure out who had a ton on their plate. And obviously that hacky system wasn't super sophisticated, so I couldn't actually see complexity. I could only get one aspect of the pie, but it was still really, really helpful in kind of filling in the gaps, right? And I'll tell you one win story that I was able to achieve with the metrics. I was able to take the volume of work coming into the team and how that changed over time, and went to the sales team and actually was able to get 4 additional headcount from the sales team to then, to then hire, right? And use that headcount on my team to support the sales work. And so, again, like metrics are so incredibly helpful for you to be able to use and substantiate resource asks from the business, much, much more likely to address it if they feel like it's concrete rather than, oh, we're just super busy and we're working on all this stuff. And then also, if you're able to get a handle, just in terms of visibility into the work, you can then use your one-on-one time with your reports so much more effectively, right? You can focus on coaching, career development, maybe drilling into areas they feel stuck, or getting a check on how are you really feeling. And I think a lot of teams, maybe using one-on-one time as a way of just getting a handle on the work that's being done. So again, leveraging technology could really be helpful in just making that time more effective. Love to hear from our audience as well. Like, what are you currently doing to oversee work? What are some challenges that you're running into? I think this is super informative, right? Getting a lot of the audience feedback. And next, Yumi, please walk us through the duty of confidentiality.
This is an easy one for us. We review NDAs on a day-to-day basis. And rather than laying out the rule in full, the duty of confidentiality here is so important vis-a-vis a third party to the legal service being dispensed, essentially. And I want to be able to highlight here that a lot of conversations have been had about how we may be breaching our duty of confidentiality. Related, the American Bar Association actually released an opinion last year on replying all in electronic communications. And so even though that one dealt with Model Rule 4.2, I think it gives us a lesson in terms of the duty of confidentiality of information and in terms of consent. And so really here, when we're thinking about confidentiality, not only are we only sharing information with people that need to know it? Do we know how the tool that we're using or the technology that we're using is actually conveying it to only the people that we're intended to? But the other thing that's overlying this is how we're thinking about access controls as well. And so just because information is not privileged doesn't mean it's not confidential. And so there are certain things that as a legal team, we must be aware of in terms of utilizing this technology. And I think if you want a link to that opinion, I'm going to drop that in the chat box. But separately, there are exceptions to the confidentiality model rule, but I think the overlying message of this rule really is that we have to make reasonable efforts. And for us, that is really looking to how does the tool actually work, reading the privacy policy, when is information going to be divulged, et cetera. And I think in the state of New York, there's a new CLE requirement now that people understand what the privacy laws are, because that's something inherent to how a lot of the technology works. And so I think brushing up on a lot of those standards with regards to privacy law is going to be important as you determine what tools do what things for your team.
Yeah, absolutely. Just double clicking, especially on the aspect of access controls, like you said, Yumi. I think that's really important for us to consider when, a lot of us are using communication tools now that's being used company-wide, right? And also using that to communicate legal counsel sometimes back to the business. So I'm thinking about chat applications, especially, which are really proliferating. And they're public channels sometimes, right, where discussions are taking place. And so it's just really important to consider, is there a risk to privilege? And what are the steps that you can take to really help you to preserve privilege over legal advice? And I think this leads very nicely to our next topic, which is something I know lots of people are curious about. I saw in the chat lots of folks saying that, they know nothing about generative AI. Some folks clearly are using it all the time. And someone wrote an ebook, I think, even using generative AI, which is amazing. So really kind of wide range of experiences. But we're going to just give you a quick summary of that in the next slide.
Yeah, and we wanted to start with maybe talking about generative AI. It looks like we've got a guy in here, John, who is evaluating the security vulnerabilities. We may not necessarily get into that specifically, but it is important to understand what the technology is first. And we do stress that there are many webinars on this topic, a lot of free webinars by a lot of great law firms out there about the use of generative AI. And here we're focusing on like what the possibility is for in-house legal teams. We want to highlight this, especially given recent events. There was like a flub that came out about Samsung engineers and how they were injecting their own code into the AI system that they were utilizing. So that's really important to understand that there's that could happen. And then there are other legal concerns too, like whether the AI infringes on copyright or other IP rights. Something to note is the current Getty Images lawsuit against Stability AI, which could be swayed by the recent Andy Warhol copyright case that came down from SCOTUS recently with regards to the Prince photographs that were referenced for that artwork. But there are also other legal implications for your other teams too. Like there's that new AI law for employment decisions that's effective this July in New York. And so to understand those implications and how they implicate the technology that we want to use as legal teams, I think Kathy's got a really good summary about what generative AI is here.
Thanks, Yumi. And so this is really in a nutshell, okay? Because like you said, there are lots of other, materials out there, including that recent CLE that was only focused on this topic. So very much encourage the audience to also look there to fill in the gaps. But in a nutshell, generative AI is technology that creates new content. And that's what I'm stressing, right? This is the difference. It's new, brand new, unique content based on prompts that encompasses things like images, articles, clearly from the audience participation, even ebooks, and video and audio. And it's pretty remarkable what generative AI platforms have been able to do. So for those of you who don't know anything about it, I really encourage you to just give this particular thing a try. So go into ChatGPT, create an account so you can actually type in something in the prompt. And this is pretty remarkable. So tell the ChatGPT system in the prompt to act as an interviewer and just pretend like you're interviewing for a new role. Tell it the kind of company that you're interviewing at and the role that you're applying for, and ask the system to actually give you question by question as though it's the interviewer. And it can literally do that and help you practice. And it's really remarkable what it can do. So, for me, sometimes I use it as advice generation, right? When I run out of ideas, I'm going to it to basically, help me go from 0 to 1. And you can basically assume this is such an easy system to use, and there are lots of them out there, that there are people at your company also using this, not just personally, but to help them with their work, which is obviously where some of the legal risk creeps in. And unless, of course, your company has a policy that's completely blocked all use, which I know to be the case for some companies. But exactly as Yumi laid out, it's important to consider how these tools are playing a role, right, in the work being performed when you're evaluating the potential legal risks. So as some examples, are people on your engineering team using generative AI to help them actually write code? Is it helping someone on your HR team potentially to create algorithms or policies? Is it getting access to PII or really, really sensitive information? And, you can kind of see some of the legal risks, right, highlighted in the slide. So here are just a few recommendations as you go about your analysis. And certainly there are other things to consider too, but just a few. One, understand how is the tool being used by folks in your company? What data is flowing through the tool? What your, business teams are actually obtaining from the system using these prompts, and how are they using it? So you'll really want to drill into the terms of service as well to see how that system is using the data, if other people are getting access to it, and ultimately who has ownership over the end product. And also consider if it's a tool that's designed for consumer use or enterprise use. So in my opinion, if the tool is designed for consumer use, but it's being used in a business setting, then, if you're running very proprietary privileged information through that, I think it's prudent to treat it with a much, much heightened degree of caution. Anything else to add to this, Yumi?
Yeah, I'm seeing in the chat that people want some resources. And so I'm dropping, the hyperlinks aren't working, but it's going to be really sloppy, but I've got some references that you guys can probably search on the internet for Meta's, Google's, Adobe's, and Oracle's AI policies that they've created and published for mass consumption. And I'm also, if you want to see this from a non-legal perspective, something that really helped me as I was developing the AI policy for my own company was something called All Tech is Human. And so we've got a lot of folks, especially at my company, where we're really trying to think about how do we be responsible companies and citizens as we are navigating not just technology, but our various industries. And so All Tech is Human has a really good introduction to those responsibilities. And I think there are other resources that I'm sure that we can crowdsource together. Hey, Shai.
Hey, so a couple of things. I want to say, very impressive, Yumi, that you can multitask so efficiently. Drop links in the chat and present to 341 people. So you are amazing, Kathy. Obviously, you too. Just want to add some color from the chat. A gentleman named John Bates dropping some great insights. He says Moderna is using ChatGPT or using generative AI, maybe not ChatGPT, to refer outside law firm RFPs. It will analyze them, rank the applicants, and show the differences between their proposals, which is really, really interesting. And he also says, if you get the enterprise version of, I guess, generative AI or ChatGPT, or I'm not exactly sure which one, but you can get the enterprise version and then you can host your own instance, so that all your confidential information doesn't go right into Microsoft servers and you won't get, in trouble and, a big media, issue like, some major electronics brand found themselves in recently.
Okay, so I know we're running a little short on time now, and we wanted to really excited actually about getting to this section too, because it's giving you some practical tips. And before we dive into that, just wanted to say that these tools that we're recommending are all culture dependent. So it depends on the businesses that you're at. There is no one size fits all approach. We focus more on tools that are more heavily focused on the topics that we talked about today, or maybe a little less known. There's a slew of legal tech we don't have time to cover, offer a lot of value, like CLM, e-discovery, compliance tools, etc. And before I kind of dive into some specifics, love to hear about your experience with some of these tools, Yumi.
Oh my goodness. So I come from very scrappy backgrounds because we want to, I'm sure a lot of you do as well. And also because of the culture of your company, you probably don't have access to a lot of tools, or you don't have maybe the soft power developed yet to adopt other tools that may be out there that are really amazing. And there are some great tools out there right now. And so if you're coming from the scrappy perspective, especially with these communication tools, there's some great things out there that your teams are probably using already. So Slack, Google Docs, etc. But there are also certain browser and email plugins where the business is already using that. My caution is really look into how that information is being used within those browser and email plugins, because the privacy policy will illuminate really what kind of information you maybe want to share through those browsers, those plugins, and understand the basics of what the business is doing to understand, is that really relevant? Is there a different tool that we could probably use? And then in terms of intake systems, you're probably all using whatever the business is utilizing to provide you with that information. However, I caution you with the context switching and information overload, and really getting people to stick to a process that really directs all that information one way. And so there are tools out there. I know Streamline is probably one of them. Also, just a big disclaimer, I'm actually not a Streamline consumer yet. So that's just if that, impacts your decisioning in any way, but I think what she's doing is great. And so there are other tools out there in terms of intake systems. And so for me, where I could start was with a CLM, where I could guide people with their contract requests, and some of their questions are coming straight and directly through that CLM, so that I don't have to go through Slack to make sure that something's confidential, that it has the access controls, et cetera. And so really looking into a tool that takes you to that next level, I think is important. And I think there are many price points out there that you guys can look into to determine what tool is right for you at this time.
Absolutely. I think the point you made was excellent, Yumi, about information overload and, looking at the tools that the businesses are already using. And often business teams don't like to switch context, right? Just like you said. And so that's why we've taken the position that, we're integrating with Slack, we're integrating with email and with Salesforce. So business teams can continue to live where they are and send those requests through. And then a little bit about communication tools, because when I first started my career and went in-house, there was a huge resistance. I remember the legal team were all rejecting using the chat application because of a lot of the risks, right? That we highlighted. But then when I went to DoorDash, I realized the entire company was living and breathing in Slack. It was a younger company. Information was passing much, much faster. And that honestly, in that context, if I didn't use Slack, I would just really, really be missing out on so much. And I learned to love it. I learned that it was way less friction. It was way less formal than email. And that's actually where I started living and breathing as well. obviously pulling the very, very sensitive stuff, right, to the side. And so really kind of quickly moving to our next attendee poll, since we were just talking a little bit about intake, we'd love to hear from you on what you are currently using to manage intake and legal requests. Love to see what you're doing there. Wow, email
Ooh, email inbox. Yeah, that's
my
winning.
gosh.
Looks like email inbox is 89%.
Yeah, thank you so much. That's really, really illuminating. So, okay, just wrapping this up quickly now, coming up to the close to the end of the hour, some more recommended solutions here for you. Workflow automation. I think we talked about this a little bit already. Historically, it was really challenging to create workflow automation without the involvement of IT. There are now no code tools available where you can do this yourself using plain English. And modern matter management, sorry, I realized that missed the word matter, but essentially helping you to track, get visibility right into all the requests that your team is handling. And then finally, e-billing solutions, providing a lot of efficiencies as well around invoice review. If you've got high volume invoices, helping you to implement, billing guidelines and reporting on outside counsel spend. But I think in some, all these different solutions, they help you to create efficiencies so that you can actually spend time doing what matters most rather than, just the high volume of very manual work, right?
Oh my goodness. Well, it looks like we've got a lot of tools that people have been mentioning in the chat. And so I recommend looking through the chat because there's some ones I've never heard of, and I'm sure that they've been mentioned elsewhere too. And so this is really great. And I love that you guys have already been seeking out tools to support your collaboration with your teammates at your companies. And so, yeah, continue to seek out those tools. We need to thrive in our roles. The ultimate goal, I think, is to be empowered by our tools to be better attorneys here. And I'm going to drop the New York Times article that we mentioned on the slide, but I feel like Kathy's got some great words to close us out here. Thank you for joining us.
Thank you so much, Yumi. I think this is something we both agree on, right? So even though we spend so much time today talking about technology, we really, both of us want to emphasize that lawyering is an innately human skill. I think you've heard Yumi say that several times is the human aspect of our practice, right? There's so much nuance to what we do. It's just not something that technology is going to replace wholesale. Even though there's a lot of buzz and a lot of talk about it, I just do not believe that's going to happen. But what we can do is leverage technology to do our work better, be more productive, right? Again, eliminate a lot of the stuff that we don't enjoy, frankly, get very little value from doing. So please get educated on what's out there. And I know you are because you're attending this webinar. Even if you've created a legal ops function, you already have one, it works 100 times better when you are engaged and you have a basic understanding of all the different options out there. And choose a tool that, fits the way that you will use it, that legal will use it, is the final takeaway. So thanks again for joining us. It's been so much fun being here with you all. And thank you, Shai and In-House Connect, for the opportunity.
Well, thank you. Thank you, Kathy. Thank you, Yumi. Thank you, everybody who tuned in. Folks, if you have questions, you can drop them in the chat. There was a number of comments, and I actually didn't see so many questions, or maybe there was one. Somebody was wondering if others have used a NDA platform with AI, if there's any recommendations. But it was really, really interesting to see a lot of people, I guess, just to sum up the chat box a little bit, a lot of what you said resonated. Legal teams are small. There is a lot more salespeople than legal team, than attorneys or support staff, and everybody's under a lot of pressure to get things out fast and updates and all of that good stuff. So legal technologies certainly are ripe for disrupt our little industry, our legal industry. People were wondering about generative AI legal policies. Do you have any advice, insights on that?
So when it first came out, when ChatGPT dropped their chat bot, that's when I had to act, because everybody was like, Yumi, can we use this? And of course, everybody was already using it. So we had to create a policy then, but we're definitely iterating. And so certainly ChatGPT is now ChatGPT 4 in its paid version, and there are a bevy of other solutions out there, especially for image creation, et cetera. And people in the chat were talking about how we may need a different one depending on who's using it, marketing, your business ops team, et cetera. And so I would say, yes, I think you can create a policy that's inclusive of every use. I recommend having principles, because the technology keeps changing and there are different options out there. Having a sanction list, I think there are also some things that there's like a summary of, I think you can also have ChatGPT summarize what those terms are, but there, I would say sanction some of them. And then if there are the subscription-based ones, those are things that you can probably utilize your own vendor review process and procedure as in terms of procurement to review those policies, because looking under the hood of each and every one is super important. Shai, you mentioned that there was an option out there where you can host it in your own private instance, and that's something that's particularly important given the confidentiality obligations you may have for your own particular work, but definitely and certainly for the work that your teammates are doing.
Awesome. So switching gears slightly, I'm wondering, Kathy, why, let's talk about, Streamline a little bit. Why is it superior than a Trello and a spreadsheet? Like, why shouldn't people stick with their email and spreadsheet configuration? Why is Streamline different?
Yeah, absolutely. So it's designed from a legal standpoint. And I think that, there is a difference, right? And when our customers, and among them, we can count Grammarly, Branch Metrics, Pantheon, Logitech, so some really big brands. When they first saw Streamline, they were like, oh my gosh, this is like, you're taking something from my mind and actually creating a solution around it, right? Because it really is from that legal perspective. We've got a legal only comment box that keeps the legal to legal communication completely confidential and sectioned away from the business, as just one example. The statuses that we have, allow you to drill into the different stages of a request. You see it when it's with legal, when it's with another business team internally, another approver, with, outside. And so that's how you can get the really nuanced SLA breakdown. And then the metrics and reporting really truly are the metrics that an in-house counsel needs, right? It breaks volume down into different matter types, allows you to see, the volume of things through different time periods, and it takes just a few weeks to set up. It's so fast.
So 90% of our audience, and probably extrapolate over we're a good proxy for the in-house counsel community, if I may say so myself. How does Streamline interact with our current processes? Like, can it take matters right from the emails? Like, how does that work?
Yeah, exactly. It really, integrates, right? With Slack. You can convert any Slack message, whether it be from a channel or your DM, into a Streamline request. You can take unstructured data that's sent to you from an email, and that gets pulled into the system as well. And that's also where the AI kicks in. The AI takes the unstructured data and auto populates the request form, as to the best that it can in terms of what data matches. And then the system goes back to the business and asks for what's missing. So historically, lawyers would have to do that manually, right? So we're saving teams a lot of time.
I think that's tremendous, just to have like some sort of, opening page where, the business can come. If they have an NDA, they click here. If they need an NDA, they click here. If they have a request, they can submit. I think that would be enormously helpful. Yumi, I know that, you've been doing a great job with the chat, and I saw some big chunks of text come through. Any new comments you want to address, or anything before we wrap up for the day?
I think we need to continue this conversation. I think there are so many community groups out there of lawyers where we can share our answers to these common questions that we've got, and we're not alone in this endeavor to be the best attorneys that we can be to our teams. And so I like to leave on that thought, but thank you so much for this opportunity, and yeah, happy to continue the convo elsewhere.
Absolutely. Well, Kathy and Yumi, Streamline, thank you so much for, hosting today's presentation, for taking a lot of hard work goes into this, folks. It's not easy to deliver these webinars. So thank you, Kathy. Thank you, Yumi. You did an amazing job. Thank you, everybody, for tuning in. If you enjoyed this program, to pipe in the chat, let us know on LinkedIn, let us know in the CLE feedback form, and definitely check out Streamline AI if you're one of the 90% or just using email and spreadsheets. It sounds like this can save a ton of time, a ton of aggravation, and just make life easier for you in the business.